The other thing that is going on, and in a way I wish Jeff was still here on this part, is he alluded to the Court of Criminal Appeals having the Criminal Justice Integrity Unit that Judge Hervey is heading up, and it is covering a wide basis of issues of how we can make the system better. And he mentioned the ID process, and this, without detail, either a sequential ID, double blind. I don't show you the 6 together. I'm going to show you one photo at a time. Double blind is that the investigator on the case is not the one that is actually doing the photos show up. So then we have the videotaping of confessions and statements. A lot of jurisdictions, the PDs and the sheriff's offices, are already videotaping a lot of their confessions. It's a very effective tool in front of the jury because there's nothing like really seeing that guy spill his guts rather than it being on a piece of paper. You all know what it's like just in life. It's better to watch TV than to, listen. As far as impact. Also, in getting more training to law enforcement officers, how can you do a better case? What are the traps you're going to walk into? What do we need to do about evidence? And I know this is indigent defense, but some of you are from clerk's offices and people that deal with the court reporters and the storage of evidence, especially when we're dealing with DNA. How long do you need to keep it? Where are you going to keep it? Should the state keep it? How long? There are all those issues out there as to what needs to go on to make the system just. Except we got a catch-22, and this is what I'd love for Jeff to have been here for. Texas has got the broadest exclusionary rule in the United States in statute. Most states don't have it in statute. It was a court-created rule even back when I was a young lawyer, maybe even before. But changing ID procedures and putting them into statute, changing requirements about confessions having to be videotaped, all that creates those little technicalities in the law that can walk us into problem with the exclusionary rule. So from the governor's office point of view, we've been offering, the new ID procedures really are good. Those videotaping ideas really are good. Do them as best practices. Train law enforcement, this is the way to go. Maybe even have a grant program for rural counties. We'll buy you a video camera. The only thing that you got to do is anytime you're going to take a confession, you got to use it. We don't care what else you're using it for. Might be some limitations, but get out there and let's keep moving things into the modern, effective world. Because eyewitness ID is really an issue now that we've seen the DNA play into that. DNA is going to play out probably in about 5 to 10 years because we're going to have covered the cases where it wasn't there, and most everybody is getting that kind of testing now. But with the exclusionary rule there, it just, so let's let Texas go to where the rest of the nation is. Most of the rest of the nation. So other states have statutory exclusionary rules, but where Texas is bigger is it says law enforcement or a person. So we could have a citizen mess up something due to lack of knowledge, and it can cause the exclusion of evidence. We also do not recognize all the exceptions to the exclusionary rule that the United States Supreme Court has pronounced. There was even a case last year concerning the search and seizure of an automobile. That will apply in 49 other states. It will not apply in Texas because we have the statutory exclusionary rule. So if we get rid of our statutory exclusionary rule and just rely on the court's rule, I'm not talking about that it would be abolished and it would no longer exist. It would just be the rule established by the United States Supreme Court that if you illegally seize evidence, you cannot use it at trial. Fruits of the poisonous tree. But let's not get it down to technicalities. Probably wouldn't change but a handful of cases every year in Texas. But it's really a bar to changing the law. The other thing that is going on, so No disagreement on the good things, but how we go about it. It's always in the details as to where you run into problems. The other thing that is going on through the Court of Criminal Appeals, and this is Judge Keller's group, and it is dealing with mental health issues and the criminal, maybe not even defendant, but the criminal. And these are some of the areas where we can divert people just because they have mental health problems from ever truly becoming part of the criminal justice system. A lot of them will commit very low-level crimes. I'm not talking about murder here. I'm talking about the stumbling on the street, little maybe teeny criminal mischief, the public intoxication, the endangering self to other because I'm not taking my medication anymore and I'm out on the street wandering around. And if there was a way that I had mental health services, then I probably wouldn't be the responsibility of law enforcement. It would help you in your county jails because you would not have the person with amazing mental health problems being incarcerated. There are a lot of counties that have already moved forward, Lubbock County, Harris County, and it's the cooperative effort between your law enforcement, your MHMR, local services, and it can be anything like in Lubbock, they have the Tech Med School there. I mean, you got to look for where your resources are. How do we get this guy picked up and taken to MHMR, get him started on the meds again, and keep him from ever becoming part of the criminal justice system? Because we got to stop the idea that the criminal justice system is our mental health system. And sometimes what's nice about the criminal justice system is if that guy gets put out on a conditional bond, and I'm not into force meds here, but we're talking about we could make him take meds or we're going to pull your bond back in. If you're totally in the civil side, there is no way to be able to keep them attached to the MHMR other than their own will. Now, the other things they're doing there would be other evaluations as the sheriff's departments would use when they're booking or any booking facility would use. Another system that should be coming out to help your law enforcement. Timing is, I don't know yet. Dee might be able to lock me down. But we're attaching some of the mental health information from MHMR to the law enforcement system. So if they stop somebody on the street, they suspect that they have a mental health problem, they will be immediately, just like I can check a criminal history on somebody, be able to see if they've ever been handled by the state for mental health issues. And that will give them a direction. It's not quite as ID friendly as the criminal information system, but it would at least get it going. Should we go this direction first instead of taking them downtown? So those are some major initiatives going on. I think you're going to see more also on your joint discovery in cases that should speed up your process. Your prosecutors, some of them are not going to take kindly to that. Today we had the issue of defense attorneys not sharing with a new defense attorney. So there's going to be some changes in laws. You know, if we can get some of that paperwork moving pre-trial, it might be amazing how we could move the system forward. Thank you all.